if you're responding to our questions when time expires, please continue. This is your opportunity to address our concerns and answer our questions, and we want to make sure that you have plenty of time to do that. So just for the benefit of the audience, the appellant, which is the party that is appealing the district court's decision, will present first. It looks like you have reserved 3 minutes for rebuttal. And then we will hear from the appellee who is defending the district court's decision, and then the appellant will have the opportunity to address us on rebuttal with the time that's been reserved. So we will, one other note, even though we are here today instead of in our regular courtroom, we are still live streaming and recording the arguments for the record. So please speak clearly into the microphone, introduce yourself when you come to the podium. We frequently do go back and listen to these arguments again as we are working on our decision. And that will make sure that the record is clear. And if everyone would please make sure that their cell phones are silenced, so that we don't have any interruptions. All right. Let me call the first case. It's Fox versus Fox, 2020-0949. Mr. Harris, whenever you're ready.
Good morning, everyone. My name is Lincoln Harris. I'm appearing for the appellant. I'm sure you're going to have lots of questions for me, but I want to kind of dig into the first issue that I'd like to address is issue 4. And I think that's the one that kind of triggers everything else. Issue 4 is the underemployment issue. With regard to the underemployment, we believe that the trial court erred by finding that Mr. Fox was not voluntarily underemployed. The court can impute to a spouse who is voluntarily underemployed, as the court knows. If we look at the case of Rayner, I think that's the one that articulates the voluntary underemployment position of this court. It says a spouse is voluntarily underemployed when he intentionally chooses of his own free will to become underemployed. It's the definition. In this case, it's undisputed that Mr. Fox voluntarily resigned from his job, making $1.2 to $1.4 million, depending on how you calculate it, and took a job making less than $1 million a year.
Mr. Harris, how should we think about underemployment? Should we compare it to, as you're asking us to what the salary was previously, or should we take a broader look at his profession more generally and see what people generally make in his profession? Should we just look at him, or should we look more broadly at the profession generally?
No, I think the court has to look just at him because we're dealing with a set of facts that are unique to his situation. From a broader standpoint, I think the court needs to find that he's underemployed because he went from a job making a certain amount of money, voluntarily chose by free will to make less money. So in that instance, he's certainly underemployed under my position and under what I believe in the court's position.
Yeah, the fact I guess I'm getting at is that there was evidence in the record that he still is somewhere above the 90th percentile in income for neurosurgeons nationwide.
Right.
And what do you make of that fact?
Well, I don't doubt that, but then if you look at when I cross-examined the expert, if you look at the additional information there, his own expert testified that he didn't consider Mr. Fox's skills and experience in various procedures when coming up with his calculations. He only used an average. So there was no determination from their own expert that he was in that just neurosurgeon standpoint. He had other skills and other abilities. So no, I think that the court didn't consider that when they looked at it. They just took average salary, what he was making at that point in time. So I think.
Does it matter what the reason was for becoming underemployed or taking a less well-paying job? I understand that if a paying spouse, were to do that out of spite, essentially, to decrease the amount of money that he or she was paying to the receiving spouse, that could certainly be problematic. But here we have the district court making findings that this was a sincere attempt to improve his lifestyle to because he was stressed, he was overworked. Does that matter?
I think it does. Because I think at the end of the day, what I think the court's going to have to say is that it's okay for someone in a specific profession to change to that within that same profession during the middle of a divorce case and go from making this amount of money to 75% of that amount of money. When the reality of that is you've just taken 25% out of that nut, which could go to both child support and both alimony. Whether it's spite or whether it's the motivation from the person, I don't think that matters a whole lot. It's the reality of what happens afterwards when that occurs.
But if we adopt that rule, does that mean that a paying spouse doesn't have the option to make career decisions in their best interest? For like an attorney doesn't have the option to go from private practice to public service, for example, because it will affect the receiving spouse?
I think that's accurate, because I think that's the question is, you're in the middle of a divorce case, you're working at Parsons or someplace and you're making $200,000 a year, and you decide to go work at the AG's
I
office.
think the market's changed in the last year.
It has. I apologize. Let's double that number and then we're okay.
You students out there are just, never mind, go ahead.
Then you decide that you're going to go work admirably, go work at the AG's office and make $82,000 a year. Okay, but how does that affect the family dynamic? Because you've made a choice then to diminish the child support and the potential for alimony by making that choice. If we compare that to, say, a modification case, where we have a substantial change in circumstance, if the court were to look at that and say, okay, this person's going to do this, would the court find that that's a substantial material change in circumstance and allow that person to do that? I don't think so under our current law. So I think we're looking at it in two different respects, but I think at this juncture, I don't think that it's allowable for someone to do that and financially harm either side. And if you look at that from the Hill case that I cited, that's what happened in the Hill case. There they conceded that he was underemployed, voluntarily underemployed. They conceded that at that case. Then they decided, well, what should we impute him at? And unfortunately, there's not enough language in that case for us to determine how the court came up with the imputation. But I think that's kind of what we got to look at. And if we're looking at it in this case, then the imputation is his prior salary. That's the best evidence of what he's able to make.
Yeah, in the Hill case, they didn't go to the prior salary. They went to some 83% of the prior salary. And does that undercut your argument that 75% is a problem?
I don't think so, because we don't know what factors they used in trying to impute income to him. I don't know if it was a straight line across. I don't know how they came up with that, because we don't have any evidence of that. I think, as I just said, I think the best evidence of his imputation of what he can earn is what his prior salary was, that he gave up voluntarily to go work at a job in Florida, making less money. Any other questions on that issue? With regard to the next issue, which is the marital standard of living, I believe that the court failed to consider the marital standard of living in its alimony calculation. Ms. Fox's expert testified that the parties were spending $70,000 a month during the 29-month period prior to the separation. And that established the marital standard of living, which was approximately $36,000 a month
So
for my client.
I think what you're saying, if I understand this argument correctly, is you think there should have been a separate finding made before the court engaged in this sort of line-by-line, needs-based analysis. There should have been a separate finding made that the total amount of expenses during the marriage was X, and then working from there. Is that the argument you're making?
I think the court needed to make that, but the court instead said that the parties could no longer meet that and basically just threw out the standard of living analysis.
I guess the
It
reason
didn't
I'm
get
asking is because that's not the way I ever did it when I was on the trial court. It's not the way anyone ever asked me to do it. It seems like, you know, as I understand the way it works, if you want to, you know, if you want to take issue with one or more of these line items on the budget and say, hey, my housing expense is too low because when we were married, I spent this much, and that's the marital standard of living. You do that on sort of a line-by-line basis, rather than coming in and saying, well, there should have been a finding in the beginning about general standard of living. And I guess that's what I'd like to hear from you on.
Yeah.
Because in your appeal, you're not challenging any of the individual line items, and it seems like without doing that, it's hard for us to sort of grab onto this argument. So can you help me with that?
Certainly, I can certainly do that. If you look at the Rule case, and the Rule gives us the way that we analyze this, and the very first thing in Rule is the court has to look at the marital standard of living. That's the baseline. And Rule even says, now, real quick. Got my tab, I apologize.
Yeah, I think you're going to point me to paragraph 18, right?
I'm going to point you to paragraph, right before that actually, in paragraph 17. The court says, as a result, if the court considers the receiving spouse's needs based only upon a reduced standard of living at the time of trial, the resulting needs determination could prevent the receiving spouse from having her alimony increased to a level consistent with the marital standard should economic circumstances materially change. If, for example, their spouse's income increases substantially. So the court at first has to start with that number. Okay, here's our standard of the marital standard of living, okay, and make a determination as to whether the parties' incomes will support that. And in this case, the court basically said they were living above their means. I mean, that's really what the court said, but they weren't. If you go with the numbers, and we go with the 1.1 or 1.4, they had about $70,000 a month, and they were spending $70,000.
I want to make sure I'm understanding Rule correctly. I mean, it does say some of the things that you emphasize. It says, you know, the court needs to do these things. It's hard for the court to do what it's doing without first determining what that standard was in the first instance. I take your point on that. But the overarching sort of point of Rule is that the court should assess the needs of the parties in light of their marital standard of living. In other words, I think what Rule is saying is you take each one of these needs in the needs analysis, and you should look at, okay, when I'm looking at living expenses or housing expense, I need to start out by looking at that through the lens of what is the marital standard of living. And it's a needs-based thing. And without challenging in particular items in the list, I guess I'm not sure how to move forward.
And I disagree with that. What you do, in my opinion, under Rule, is you take the marital standard of living, then you come down from that and you put in the child support on both sides, add it to one, deduct it from the other. You deduct from that what the marital standard of living is. Here we have $36,000 and $33,000. You subtract that. Now you've got numbers down there. If you do that for this case, you've got some money that Mr. Fox can pay, and you've got a shortfall for Ms. Fox. Take those two numbers together, you divide them in half, and now you've got an equalization, which is what the court failed to do here.
If the court gets to the bottom of its needs analysis based on what it thinks each one of these needs are, viewed through the lens of the marital standard of living, and that number is lower than what the expert has said, you know, this was the overall expense number, what does the court do then? Does the court have this sort of, you know, this difference between $25,000 and $36,000 that you're pointing to, and then just give an additional $11,000 for just general needs? I mean, how does that work?
No, because what you're looking at there is you're looking at the time of the divorce versus the time of separation. The marital standard of living is at the time of separation. So at that point is when the court really needs to look at this and say, here's the standard of living. And at that point in time, they could be met. They had $70,000 coming in and $70,000 going out. So then what the court did instead was go to the Jones factors and looked at the Jones factors and said, no, I'm going to take some of these down now without any justification for doing so, without considering, okay, what the marital standard of living was, because they threw that out.
But which ones are you taking issue with? Right? That's what I couldn't find in your brief.
I'm not taking issue with any of them. I'm taking issue with the approach. It's the approach that's the problem, is because if you follow Rule, again, all you've got to do, plug in the numbers, salary, okay, subtract out the child support, take the marital standard of living, deduct those numbers, come up with a shortfall, divide that in half, and that's equalization. Here, the court didn't even get to equalization. They actually got to the bottom of the Jones factors, determined that he could afford to pay her what she had, and let him keep the surplus. So at the end of the day, he had $4,000 more than she did in a case where the court found fault.
But we have cases, do we not, that say that equalization comes into play only where the one spouse's ability to pay is not adequate to take care of the demonstrated need. And I think I've written an opinion or two where we say that the demonstrated need is the maximum available for alimony.
Correct, and that follows just what I just said. So we take those numbers, we subtract them out, we've got them on both sides. If you take these numbers, he's only able to pay about $10,000. She has about a $24,000 deficit if we take the marital standard of living. And again, we add those two together, and then we try to equalize.
Then we'll equalize the shortfall.
Correct, and that's the approach. That's the right approach. And here, there was no equalization.
I'm still confused though, because if her needs as computed by the court on this chart can be met by the payor spouse, then as Judge Orm indicates, we've got a lot of case law that says her demonstrated needs is the ceiling, right? So there is no shortfall. So what is there to equalize?
Her demonstrated need is the standard of living at the time. So it's $36,000.
I guess that's where I'm having a hard time with where you're coming from.
Right, but that's where you've got to start, and that's what the case law says. That's what the rule says. You got to start. I'm out of time. I'm sorry. Any other questions?
Thank you very much for your argument.
Appreciate it.
I know that, I'm sorry, Adam Caldwell for Ben Fox. I was just going to let the court know that I know we've only covered 2 of the 5 topics. There are 3 topics that we haven't yet discussed, but I did want the court to know that my arguments on those topics were going to be impressive.
And before you get too much further into your argument, Mr. Caldwell, I just want to say thank you for driving up from the Southwest. This is our first in-person argument, and for you, this was not particularly convenient. So thank you for making the drive.
That's right. It was a flight, and the pilot did an excellent job.
Okay. Well,
We do have airports in St. George.
Thank you for traveling here to be with us.
Thank you. I think maybe I'll start just kind of in rebuttal to what Mr. Harris has said and maybe go from there. Let's start with the issue of the underemployment, and I think the issue is if that really is the definition that Mr. Harris indicated, if that's our definition for underemployment, I think we've got a problem with that, because the definition literally it's basically saying, well, a person is underemployed if they're underemployed, and I don't necessarily think that works. And the other point that I wanted to just quickly make was where Mr. Harris argues that Mr. Fox takes this new job essentially in the middle of the case. And I think it's important to keep in mind that his job search was not in the middle of the case. There is an ample record that Mr. Fox was burnt out, unhappy, the current job was not working for him. There is evidence that Ms. Fox accompanied Mr. Fox on job interviews, including her own family helping him line up job interviews. And so yes, the ultimate change did happen essentially in the middle of the case, but the searching, the unhappiness, the trying to find the new job happened well before the party separation.
Let me ask you a question
Yes.
about that. It's the same question I asked before. Does that matter? Does motivation matter? Because we do have a finding by the district court that his motivation in seeking the job change was not to deprive his family of support, correct?
Yeah, no, I think motivation certainly, is one of the factors that certainly should be considered by the district court in why is this job change coming about. At the trial level, I think that is an important issue.
Does it also matter? I don't know if it does. Does it matter if the couple before the divorce had jointly agreed to a job change?
I think again, it's kind of like with the Hall case, where it's talking about there are several factors to be considered, and I don't know why that wouldn't be an appropriate factor to consider as well. Obviously, each case each case is going to have different set of circumstances and facts for why did you move from one job to the next. And I think if that was something that they were openly discussing, that also would be a factor, at least for this particular case, for the court to take in as a whole in weighing the various factors for whether or not this should be considered underemployment in this particular case.
I guess I wonder how far this principle goes. If your position is, well, somebody who's, involved in a divorce and been working really hard, a lot of,
Right.
I've seen a lot of these cases.
Sure.
It's
Yes.
not atypical for one of the spouses in the middle of a divorce to say, I've been working too hard, that may have been in part what led to the divorce, and I'd really like to work less. So, if he takes a different job that's 50% of his income instead of 78% of his income, or 40% of his income, I mean, where is it that we can sort of draw the line? We can't, there's got to be a line to it at some point, isn't there?
There could potentially. I know in this case, my recollection was the Hall case was something like 83% or something like this, and in this case, we're looking at, depending on whether or not you consider the tax implications of Utah versus Florida, you're either at 74 or 78%, depending on how you want to look at that. And I suppose the answer is kind of both yes and no, because at a certain point, if the court determines that an individual is burning out, can't sustain what they're currently doing, then at a certain point, I don't know that it matters, because if the end result is, if this road is going to be a dead end, then I think it's more of a discussion of, okay, if this road is a dead end, then what else is this person reasonably capable of doing before we consider him to be underemployed? And as in this particular situation, where we have a vocational expert that has come in, has basically said, okay, look, we've looked at this, we've looked at what neurosurgeons are making. The average neurosurgeon in Utah is about, I believe, $588,000. The 90th percentile for a neurosurgeon nationwide is about $923,000. And in this situation, we have it where Ben is making $981,000, so he's well still into the 90th percentile for what he's making. And there's both also in the briefs and the record, we have the examples of where even when he left his position, they weren't simply able to replace him. So instead they had to bring in three radiologists to help cover this, they had to bring in a new neurosurgeon to cover this, and they had to stop doing, I believe it was the brain aneurysm, so they just had to stop doing that altogether. And they also stopped doing a certain type of call that Ben was doing. And so they essentially took 4 different people to have to replace this one individual. So yes, it certainly is a good question as far as, well, where do we draw that line? But I think in this particular case, where Ben is still well within the 90th percentile, still working 50, 60 plus hours a week, I don't think we have to worry about that line in this case, because I think we're rather far from it. But it certainly does, it certainly is a good question, but I think this case we're pretty safe in fully gainfully employed territory.
Yeah, I take your point, and the point that's being made that motivation may play a role, but that can only go so far. If there's a finding that, well, he didn't really intend to, he wasn't doing it on purpose to lower the alimony, but he's got a job that's 25% of his previous income because of work-life balance. At some point we'd have to go, come on.
Yeah, and I think you also have to look at it, I think the argument can potentially go the exact opposite direction as well, that if you, in here theoretically we have a fact pattern where, okay, well wait a minute, my husband's making X amount, now suddenly he's looking for different jobs where he could potentially be making less. I better get in there and file so that I can freeze him at this particular income level, for the rest of his life. And so again, I think it is pretty fact intensive, because you very well could have a very similar case with what appears to be somewhat similar facts, but you very well could get a different result. And that's why I think it is kind of very trial court intensive to weigh the particular evidence and testimony for this particular
On these facts, could the trial court have come out differently on this? Could the trial court have made a finding that he was voluntarily underemployed that would have been supported by sufficient evidence? We've got a situation where we've got a history of him working 80 hours a week, a history of him making up to $1.4 million, and we got about a 25-ish% reduction in income that happened right after the force. Are those facts sufficient to sustain a finding in your view, at least of voluntary underemployment?
Yes, I think the trial court could have got there, based on the weighing of the evidence, weighing of the credibility of the testimony. I think I would take issue with it, where we have the Rayner case and the 83%, where but yes, the answer is yes.
And so this comes down to standard of review then, I guess, because you're taking the position that the opposite finding is supported. So in your view, is this a standard of review kind of situation?
I think the trial court, with weighing the evidence and the individual facts of this case, based on weighing the testimony of the court, realistically could have made the other finding. So I think the answer to that is yes.
So either finding supported. Yeah, go ahead.
Do we review for abuse of discretion or for clear error?
That is a good question to which I do not know the answer. As far as, so if there's no other questions on underemployment, I want to turn to the issue of the standard of living. And I've had a struggle to, I think, to fully understand the argument that is being tried to made here. But and it kind of seems like, from what I've heard today, it kind of comes down to the argument of, well, in the findings on paragraphs 66 and 67, what the court has done is made 3 columns. And instead, what the court should have done is take these 2 columns and make them 2 separate single columns, creating a new section that says, okay, here's your marital standard of living, and then here's what I'm finding should have been done. But because the court combined those into one thought process, that therefore, the court didn't follow the rule case. And in this case, I think that our court, the trial court, did follow rule, because the argument is, well, rule just skipped all these steps. And in this case, I think the record's clear that the trial court did consider all of the evidence as far as what the parties were historically spending, and then the trial court then concluded, okay, I've considered this, but I'm also finding that this doesn't work. The parties have a history, and the court specifically finds that the marital standard of living was pretty simple to determine in this case, because the parties spent 100% of everything they made and then borrowed money on top of it. And so it's pretty easy to conclude that when you're essentially your marital standard of living is 110% of what you make, that's pretty easy to conclude that that's a marital standard of living that can't be sustained.
So can I ask you a question about
Yes.
that? It was the only evidence at trial, the testimony of Brad Townsend about the marital standard of living?
Between the
Was like 70,000 to 100?
at a point, 72,000, I think, is what they were spending the prior year. No, well, it was a combination of the testimony of Mr. Townsend and the financial declarations of both the parties and the parties themselves. But no, there wasn't a separate expert that was brought in. I think it's pretty much acknowledged that if the parties made 72,000, they spent the 72,000 and borrowed money on top of that.
So the marital standard of living, the number was undisputed, essentially.
As far as its income, yeah. I mean, fortunately, this was a case where the income really wasn't in dispute. I mean, he was a W-2 employee. It was fairly easy to see what the income actually was. But in this case, again, the issue for once the court had determined that, okay, here is the income, yet the parties literally had no savings, nothing to show for it at the end of the day, because they literally spent everything that they brought in, and then borrowed on top of that. Obviously, we have the kind of the analogy to the blanket that fits on the bed. You cut it in half, and now suddenly it doesn't fit. In this case, we had a situation where the blanket never fit to begin with, because the parties were always expanding their bed at a larger rate than the blanket, being the income, was ever at. And so in this particular case, really, at the end of the day, all the court has really done is essentially said, okay, you guys cannot afford a $20,000 a month house. And so instead, we're going to have to trim that. Because if you look at the individual expenses, both on, sorry.
Sorry to interrupt, but
Yeah.
I guess I'm still having problems with the issues that Mr. Harris and I weren't seeing eye to eye on, which is, why does equalization of poverty conceptually even matter here? Where we have a finding from the court that the payee spouse's needs can be met from the
Yeah.
payor spouse's income. We're not equalizing anything. The
Right.
needs are being met, according to our case law, that's the maximum that the payee spouse is entitled to. Aren't we kind of done?
I agree. I think we are done, other than the fact that I've got 2 minutes left on the clock.
Okay.
But so I was going to say that you're right, that the court concluded that the $25,424 was what she needed, and based on the imputation of income, the alimony, and the child support, the needs are met. And I guess my only point to the arguments of, her needs is that when the court concluded that the $20,000 a month for just a house isn't going to work, that's, if you look at the individual items, that was really the only one that took kind of a significant cut. And then if you look at everything else, there are 14 of those individual items where Ms. Fox was awarded every penny that she asked for. There were a couple where she was awarded more than she asked for.
To that point, yeah, as far as I can see, there were 4 items that the court gave the payee spouse less than she asked for, and those mostly had to do with housing expenses. It was rent, mortgage, real estate maintenance, utilities, and telephone. And then there were 3 categories where the court gave more than what was asked for, and in every other category, it was a to-the-penny award.
Correct.
Well, am I understanding that right?
You are, and really the biggest, and in fact, if you just take the house out of it, and you take the house out and isolate the rest, she actually got, I think, about $50 a month more when you take the ups and downs from the other adjustments. And so she really, other than the house, which the court just said was impossible to continue, pretty much everything else was there. And the court basically, between the housing allowance for Ben, which was $3,000 a month less than what Ms. Fox was awarded, but you take the 9 and the 6, and you really are kind of back to the 15, so you're within 1,000 what the parties had at the marital standard of living. Clearly, this is a situation where both parties can't have a $20,000 a month house going forward. The court recognized that. It made adjustments to the house, and I think everything else is there. With that, I see I've got about 10 seconds left.
And maybe this is a question for the other side, but is the house been sold? Do you know?
The house has been sold, yes. Yep. Thank you.
Well, and I'm sorry, one
Oh, yeah.
other question. No, I'm sorry, this is for the other side.
Okay.
I will let you sit down, thank you.
Even better, thank you.
And before you begin, Mr. Harris, my comment to Mr. Caldwell about thank you for traveling up, I realize none of the other lawyers had to drive all that far to get here, but your client did.
Yeah.
And I appreciate her being here as well and making the effort to be here in person as well. So thank you to you as well.
Okay, let me begin with a couple of things. The job search issue. I don't want the court to lose sight of the fact that Ms. Fox's testimony was that he wanted to practice in his specialty and he wouldn't take a job making less than the job he had. I want the court to lose sight of that fact.
When it was a joint goal, that was the position.
Correct, correct. I think Mr. Caldwell proves my point regarding the imputed income. As he said, Mr. Fox's skills were above and beyond the average neurosurgeon. He knew how to do this, and he knew how to do this, and he knew how to do this.
He's
When he
doing
was replaced,
the work of 3 men.
right, but when he was replaced, they needed 3 men to replace him.
Or
Okay, so I think he
doctors,
proves my
physicians.
point regarding what should have been imputed, which was that income for that specific individual with that skill set. So that's my point there. I want to touch on just a second on the minor case because I know Judge Harris authored that opinion and Mr. Caldwell was actually an attorney on that case. And in that case, we get this result where we have Mr. Minor arguing that he made about $1 million a year. And because the court was going to award him 50-50 custody, I believe, if I'm not mistaken, you guys probably know this case much better than I do, but the court would not let him reduce his income down based on that factor. So just because he wanted to earn less money and because he wanted to take care of his kids, the court didn't let him do that and imputed the income or went with the historical income in that regard to about $1 million a year.
Yeah, is that a standard of review issue though? I mean, Mr. Caldwell wasn't able to help us out on the standard of review here, but isn't it a deferential one?
I think it's clear error if the court doesn't apply the standard, which is, in this case, as I said, the definition, the clear definition is, if you willingly leave your job, you are voluntarily underemployed. And then it goes to the imputation period. So the court didn't find that. The court said he wasn't underemployed. So the court made an error in that regard.
I guess my question is voluntary underemployment seems to me, I think, to be in the nature of a factual finding that we would defer to if it's supported by evidence. And I guess my question to Mr. Caldwell is, he conceded that the evidence would have supported the opposite finding. And my question to you is, well, isn't there enough evidence to support the finding that the court made? I mean, is this a situation that would lend itself to the trial court being able to go either direction here and being affirmed either way?
No, I don't think so under the definition. The court had to find, based on his willingness to leave, his voluntary withdrawal from his employment, that he was underemployed. Now the court goes through another analysis and tries to figure out what should he be imputed at. So I think it's a two-step process. So I think it's clear error to find that he wasn't underemployed.
Yeah, it's two steps. You've got to find he's voluntarily underemployed, and if you find that he's not, then you don't need to impute, right?
Right.
You only impute if you make a finding of voluntary underemployment.
And the court should have done that based on his voluntary leaving his job.
Let me ask you a couple
Yeah,
questions
sure.
about the marital standard of living question. It seems that it's pretty much undisputed, and your expert put on the only testimony about what the marital standard of living was. So it seems as though we can probably assume that the court impliedly found that that was marital standard of living, and that could not be sustained. So is your argument, though, that instead of going to the needs analysis, basically the court had to look at what the marital standard of living was and completely equalize that so that, and I cannot find the number. I know that Mr. Fox had a surplus
Correct.
each month. What was that?
$3,700.
$3,700.
And he built $2,000 in retirement into his side of the fence.
Okay, so really what you're saying is because the marital standard of living was higher than the needs, that $3,700 and possibly also the retirement should have been split equally, that excess,
It
is
should
that
have
right?
been equalized. I can't say that it would have been split equally. That's certainly up to the court to make that determination. But you have to go through that process of equalization. And that's where Judge Harris and I disagree. You know, I think you have to start with that standard of living because that's the testimony. This is what they have. And the court basically ignored that and said, no. But if we look at the marital standard of living, it was the same as the income. It was around $70,000. They spent what they got, and that's what the standard of living was. The only reason that we're dealing with this, and Mr. Caldwell talked about the blanket analogy, the blanket doesn't fit here because you reduce the size of the blanket. That's why it doesn't fit. It fit before. There was 70,000 and there was 70,000. So now you reduce the size of the blanket. Yeah, it doesn't fit. Now you're down to 52,000. You still got the 70.
But when, just a moment ago, and I appreciate your candor, you said, well, no, it doesn't need to be split equally, it just needs to be equalized.
Right.
And of course, the district court does have some discretion in deciding how to distribute this income. Is a $3,700 difference, given the type of salary and income that we're talking about here, is that going to be an abuse of discretion? Is that going to be so arbitrary and capricious that it would require a reversal?
We don't know because the court didn't go through that analysis. That's the piece that the court's missing. The court should have gone through the analysis, found the shortfall, and then done the equalization. The court didn't do that. The court stopped at the Jones factors and said, you get this much, he gets this much. There's no equalization.
One other housekeeping matter, do you agree that the parenting camp and the coach, that issue is moot at this point?
I guess I have to say that because it ordered them to do it within a certain period of time. One was within a year, one was within 6 months.
And it wasn't done, so there was no money expended on that?
There's no money expended. So I would agree. Anything further? Thank you very much.
Very much. Thank you very much for your arguments today and for your briefing. The arguments were very helpful and a great example to our law students. I really appreciate you showing them two great attorneys in action and representing your clients so well. So thank you so much. We will hear the next case.